Hi, everyone, and welcome to the Well Acquaint podcast, where we empower our communities one episode at a time, each and every perspective at a time. I know it's been a while, but today we have a special topic. We will be discussing a pending Supreme Court case called 303 Creative LLC v. Elenis. And just a brief synopsis on the pending Supreme Court case. Lorie Smith is the petitioner. She is a web designer who creates content that is consistent with her faith. She designs websites that promote her understanding of marriage, and she posts explicit statements explaining that she can only speak messages consistent with her faith. CADA, C-A-D-A, is the Colorado Anti-Discrimination Act, which requires her to create customer websites that endorse same-sex marriage. Free exercise clause is being triggered, and the establishment clauses, right? So the free exercise clause, just a brief synopsis on that, it prohibits the state from punishing someone solely on the basis of the religious beliefs. And the establishment clause fall up under the umbrella of the First Amendment. The state here is looking to impede her ability to write on her websites based on her sincerely held religious belief on same-sex marriage. She's arguing that the state is looking to restrict her speech based solely on the content because it is a content-based regulation or content-based restriction. The strict scrutiny is being triggered, and lower courts have held, specifically the 10th Circuit has held, that Colorado has a compelling interest. And that compelling interest is to ensure access to websites created by the petitioner to coincide with their particular message of not discriminating against same-sex marriage. And this particularly prohibits Lorie Smith, who owns 303 Creative LLC, from publicizing and creating her own express understanding of marriage. Nneka, what do you say as far as your opinion on this pending Supreme Court case?
Yeah, thanks for that synopsis, Tam. I will also note before I give my specific answer is that under CADA, which you just referenced, Colorado's Anti-Discrimination Act, it's important to note, just provide the audience with some context, that this is a what they refer into in the petitioner and the respondent's arguments. And just to be clear, their arguments were heard recently before the Supreme Court of the United States. I believe it was December 5th. And they refer to CADA as a public accommodation law. And so what that means is that because the petitioner's business is a public business, it's not a private business, under CADA, that law, she's required, because she's providing a service to the public, to accommodate and provide services to all people, which means that she cannot discriminate, particularly in this case, on the basis of one's sexual orientation. That's one of the issues that's in dispute in this case. And as Tamara had mentioned, in this case, she's refusing to provide her services, her web development services, to same-sex couples, because obviously that's against her religious belief. And so how do I feel about that? I think this is a tough case. I'll say that I think when it comes to free speech and the exercise of religion, no one should be compelled or forced to do anything that is inconsistent or against their religious beliefs in this case. That is one of the most tangible inalienable rights that we have under the Constitution, is our free exercise of religion. So that's my kind of answer to you. But I'll also note, many of you may be aware of what they refer to as Supreme Court, the Master Cake Shop. I forget the name of the case, but this was also out of Colorado. And in 2018 or 17, this is a guy who owned a business in Colorado. And I'm raising this because it's relevant to this case. He designed cakes, and he refused to sell these cakes to a same-sex couple. Long story short, the Colorado Civil Rights Commission said that it was a violation of CADA. It was discriminating based on one's sexual orientation. He appealed that case and made it to the 10th Circuit, and then it made it to the Supreme Court. And what the Supreme Court said in that case, which is also going to have some bearing on the case that Tamara and I talk about now, is that Colorado Civil Rights Commission got it wrong. That, in fact, requiring this business owner to make a cake for same-sex marriage, same-sex couple, was disparaging and hostile towards his religious beliefs. That's what the Supreme Court said in 2018. It was a 7-2 decision. And so I think it's important to note that case, because I certainly think it's going to give us some guidance as to what we're going to see here in this case.
Right.
I was just also going to say, I think I briefly listened to the oral arguments. I'm curious on what your thought is on this. I think a lot of people get into their emotions when it comes to these type of cases. Obviously, it's about religion. Obviously, we're dealing about a same-sex couple marriage here. But it's important, at least from how I analyze the case, it's that there seems to be an issue between the respondent and the petitioner in regards to whether she was discriminating based on someone's status, or was she just really just refusing a service because it was inconsistent with her belief. So, for instance, I think there may be an argument that the petitioner may have refused to a heterosexual couple to provide web designing if they wanted her to put something on the website that was in fact in contravention to her religion. So I think there's an argument to be said on the petitioner side that does this really have to do anything with orientation? And in fact, is it merely just about her religious beliefs? I think we have to really consider that as we analyze this case, because the Supreme Court says that, state laws are required to compel speech, compel your, and this is a speech case, any type of speech that's inconsistent with your religion or your beliefs. That is huge implications for all of us, regardless if you believe in gay marriage or not.
I took a look at their brief that they filed on the initial writ of certiorari. And from my understanding, based on what her counsel is saying, is that she is really open to working with all types of backgrounds of people, same-sex marriage couples, straight couples, regardless of religion or sexual orientation. However, she doesn't want to be compelled to post statements that endorse or condone same-sex marriage because it goes against her sincerely held religious belief. So that's why the free exercise clause and the establishment clause being triggered here in this case, and that's part of her counsel's argument. I will also note that it seems to be a trend in the last few years that the liberty of religious beliefs and people that don't want to condone or do certain activity that goes against their sincerely held religious belief have constantly seemed like they've had a target on their back. And that's why cases like this is very chilling for people that have sincerely held religious beliefs. Look at cases such as Capitol Hill Baptist v. Browser, Harvest Rock Church v. Newsom, which was a case out of California that this California church was told to cease all congregational activity of worship due to COVID-19. The Roman Catholic Archbishop of Washington v. Browser, that was a case out of DC, posed COVID-19 restrictions on houses of worship. So again, we've just been seeing a trend, an unfortunate trend, religious activities, sincerely held beliefs constantly being targeted, and it does create a chilling effect on those individuals that do have and hold sincerely held religious beliefs. And another thing too, I just want to mention is that with these cases, now the cases that I just named, not all of them reach the Supreme Court, but these are churches and small businesses, which also creates a chilling effect when you are a small business, or maybe you are a small church, right? If you don't want to condone or be compelled to do certain activity based on your religious belief, will you be targeted? Will you be brought to court? A lot of small businesses cannot afford to spend hundreds of thousands of dollars on litigation, to hire attorneys, to take their cases to court. So again, it creates a chilling effect for churches, especially small churches, small businesses. I will also note that the dissent for the 10th Circuit, Chief Judge Tim Kovic, he said, quote, "The rule is unprecedented and staggering in scope." He further said that this empowers the state to force everyone to speak an approved message and subverts our core understanding of the First Amendment. And when I read that, I thought about communism. And because we live in America, and because we haven't really experienced explicit communism, a lot of us don't know the red flags of communism. When the state is trying to compel someone based on the First Amendment rights, based on the fact that, okay, well, this message is not approved by us, and you can't say that, you can't express that, you can't write that. That is a red flag, and that's very chilling. So residing in Florida now and knowing people that have migrated from communist countries such as North Korea, such as Vietnam, Cuba, they recognize communism, right?
I think it's a little bit of a stretch.
So, right. So let me just finish this point. Communism is totalitarianism, right? So pretty much when the state does not approve of a certain message, and when they don't approve a certain message, you can't speak against that. And for me, it seems like that CADA, or the state of Colorado in this instance, has been able to bootstrap these restrictions and just compel her to pretty much post statements about same-sex marriage that are against her sincerely held religious beliefs. And to me, that is gerrymandering. But I'll just stop there and I'll let you respond.
Well, you said a lot of things, a lot. The first thing I want to point out that's really important for this case is that she has suffered no harm right now. Let's be clear on that. The petitioner has suffered no harm. For those who are not clear of that, under the Constitution, under state laws, in order to bring a case before the Supreme Court, any court, you have to have standing, meaning you have to have suffered some type of harm. So while she has standing, this case is different because as it's termed, what the Supreme Court has termed, a pre-enforcement case. So you indicated that there have been a lot of statutes and laws where people's religious freedoms have been triggered or attacked, whatever word you use. Let's just be clear in this case that CADA have not compelled her to do anything yet, because this is a pre-enforcement suit that's before the Supreme Court. They are very narrow types of cases that are only heard in very seldomly instances, and of course it's heard in this instance. So currently, right now, while the petitioner has standing, she has not violated any provisions, particularly the accommodation clause, which is in dispute under the CADA Act in this case, nor has CADA in this case compelled her to do anything against her religious beliefs. So I just want to be clear on that for the audience, that she has not been harmed yet or been compelled by any state law in the state of Colorado. Secondly, I think, this is important. And I think one of the issues that was brought up, and I'm curious to get your perspective, is, one of the questions that the Supreme Court justice raised, and perhaps that is in contention between the parties, is whether it's about the what or is it about the who in regards to the issue in dispute. Because the issue in dispute is whether CADA will violate free exercise and free speech clause under the First Amendment. And what I mean about the what and the who, is she refusing these services because of the status-based protection? Status-based protections meaning one's sexual orientation, one's race, one's religion, or is she refusing these services because of the what? Because of the message that it conveys? This is a free speech case. And what I mean by that is that the services she's providing, as petitioner argued before the Supreme Court on December 5th, are symbolic. And so because they're symbolic, they're speech. And the Supreme Court has already ruled decades ago that symbolic speech is speech and is protected under the First Amendment. So I'm curious on your thoughts, although I probably know what you're going to answer to that question. Is she refusing these services based on the what, the speech, or is she refusing these services based on the who? What do you think?
So just to kind of respond on the statements that you just made as far as standing or juxtability, in my opinion, this is a live controversy, right? So you have rightness, you have mootness, and this
what
is an
harm
existing.
Has she suffered?
So CADA is an existing law that Colorado has passed and is currently looking to enforce and compel her speech. So this is a live controversy. It is not moot. It is ripe. So to me, there is standing, because if
there is standing, I don't dispute that.
So thank you for letting me finish my point.
I just want to be clear, just before you finish, Tam. I just want to be clear. I just want to be clear. Like, I never said there wasn't standing. I said there was standing. Of course, they're standing, or she wouldn't be here and we wouldn't be discussing the case. I never said there wasn't standing. There is. What I said is that she has not yet suffered any harm. This is a pre-enforcement lawsuit before the SCOTUS.
Right. So if you're saying that she hasn't suffered any harm, then this case would be moot, right? And there would be no standing. So she has suffered a harm, right? So meaning that she's being compelled. Her harm is that she's being compelled currently right now to post statements. Now, we're not talking about conduct or services. And that's another point that I wanted to respond to you too, because it's not about her conduct. She's being forced to post statements, write statements condoning and endorsing same-sex marriage. So this is just not a service. It's about her posting statements, explicit statements on her website that go against her sincerely held religious beliefs. That's how you trigger that content based on the content of her speech. So that, again, is First Amendment. And I don't want to go into all of that. I guess to answer your question about the who and the what, which I think I just answered, I think it's not necessarily about her conduct, but her freedom of expression, freedom of thought, and being able to write or condone her religious understanding of marriage. And CADA is not allowing her to do that. And the accommodations clause, just a brief synopsis, it puts certain regulations on public establishments, meaning that places that may be open up to the public, such as restaurants, gas stations, small businesses that serve the public. The accommodations clause restricts anyone from discriminating based on race, national origin, color, and religion. But the CADA law provides more protection, and it adds in that same-sex marriage. So that's why CADA is very, very important to note here, because this is a current controversy and this is the right case. And this is not moot. And she does have standing. To have standing, you have to have a current harm, right? So I just wanted to respond to that as well. I think it's very interesting to also note that in the 10th Circuit holding, they made a particular statement that I want to comment on. And they even admitted that this is gerrymandering. And if you don't know what gerrymandering is, it is you're manipulating the boundaries, you're manipulating laws and regulations to uplift a certain viewpoint versus a contradictory viewpoint. And I think that was really interesting to read. And again, these are based on and a lot of opinions of a lot of Americans based on red flags of communism. And it's very scary to really be in a country where you're not able to express or write certain statements on your personal website or blog based on a message not being approved or condoned by the state. So that's scary.
I think what's interesting, and one of the things that Justice Sotomayor pointed out when the respondent for the state gave his argument, and what's going to have some huge bearing on this case, which is why, as I mentioned before, the Masterpiece Cake Shop case is going to be so important and certainly guide the justices as they reach a decision in this case, is that there is no Supreme Court precedent at all. Precedent meaning there's no law that the Supreme Court has yet to rule on that hold and find a state law like CADA unconstitutional under the First Amendment. And so Justice Sotomayor had noted that, and I thought it was interesting, and I understood why she noted it, but I'm wondering, and I don't think it's really going to have much influence on the current Supreme Court now, as it's a super majority in regards to some conservatives, as we know. But it was interesting that she raised that, because there's no precedent. There's no Supreme Court precedent on this type of issue, on this type of case law. And the closest it gets from the Supreme Court status is the Masterpiece Cake Shop. So I'm curious on your thoughts on that in regards to just the precedent, not trying to get too legalese for our audience. But another thing which I felt was interesting, and perhaps this is what the petitioner wants to do. This is what I at least interpreted when I listened to her argument, and the respondent kind of responded the same, is that perhaps there's a disclaimer that you will define the contours of your services, meaning that I will provide so-and-so services, but these are services I won't provide. You know what I mean? Like I won't make cakes for same-sex couples. I won't provide my web services or design a marriage website for same-sex couples. And that seems to be something that petitioner, at least from when I read the argument and how I interpret it, they're willing to do. And that the respondent on the other side also seemed open to, so long as you provide those services to everyone. So I'm also interested in what your opinion is on that, because perhaps that may set the precedent and be a guiding point to businesses in the future when they put those type of disclaimers forth. And obviously, this is what the respondent kind of raised. Being able to do that will certainly probably pull business away from them. Heterosexual couples may not want to go there because they know that this person doesn't provide that service to same-sex couples, et cetera, et cetera, et cetera. So I'm curious on what your thoughts are on that. And my third point is, for those who are on the side of CADA, Colorado, and not for the petitioner, I imagine many of them are saying, you know what, this is a public business. This is, you're being regulated by accommodation clause under CADA. This is a public business. If you don't want to serve these people, then don't be public. Be private. And so I'm hypothesizing, but I imagine that's probably what some of the people on the respondent side are saying is, don't serve the public then. Privatize your business. And I think one of the justices raised that too. It was actually Justice Jackson when she asked a question to the petitioner's counsel, and she let her know, yeah, but you're not a private business. You're public. So you're providing these services to the public. So I know that's a lot. I put 3 points out. I'm curious on what your thoughts are on those, if any.
So I kind of want to clarify something that I said about standing. This came to mind. So again, going back to the argument, not to rehearse anything, but standing requires rightness, and the case cannot be moot, causation, and redressability. And I think that is what I was trying to articulate, but I did not articulate it very, very well. So that's for destructibility and for it to be a live case in controversy. Regardless, respond to your statements in regards to what you just said. I think it's very simple. From my understanding of the case and based on what our counsel said, again, I'm going back to my remembrance of their initial brief with Lorie. It really goes back to not her conduct per se and her serving, because she admitted that she will work with all backgrounds of people, including LGBTQ people. But it's really compelling her to post statements on her blog that condone same-sex marriage, which is contradictory to her sincerely held religious beliefs. So I think that's where the case in controversy is compelling her to post statements of same-sex marriage, right, that she does not agree with because she is a public accommodation. And really going back to just and I guess in my opinion, and a lot of Americans' opinion about the simplicity of this case, it really comes down to, do you respect someone's sincerely held religious belief, despite you not agreeing with their viewpoints? Do you respect that? And I think that that is explicitly what is allowed and permitted under the Free Exercise Clause and under the Establishment Clause of the First Amendment of the U.S. Constitution. And again, just to kind of rehearse what I previously said, it's very chilling. This case and a number of other cases that have came before the Supreme Court are, I won't say the Supreme Court, but cases like in DC and California, places where it's more, I won't say liberal because I don't want to be stereotypical, but places where it seems like small businesses and churches have to literally fight to be able to express and be able to hold their sincerely held religious beliefs. Again, it's very chilling. So we will see what happens. Is there anything else you want to add?
I do have a comment in regards to what you said earlier before the chilling in regards, I forgot how you phrased it. It was something about what she's putting on her website or is stating stuff for same-sex marriage. And this is another thing I want to just comment on. And one of the things that was a back and forth between the petitioner and some of the justices is that, and even, Justice Barrett, many of them imagine that these marriage websites that services that she's going to be providing. I believe in this case, that's the service she was going to be providing, to create a marriage website, a wedding website with their date, all of that for the same-sex couple. And one of the justices proposing and asked the counsel for the petitioner, well, isn't that just all plug and play? You just put the date for the wedding, things to do in the city the wedding's located, pictures of the couple. Is there anything that you're putting on that website that's saying, I support a same-sex couple? And from my understanding of when I was listening to the arguments being made, no. There's nothing in regards to when she provides this service that's gonna say explicitly, I support or I this or that endorse same-sex marriages. In fact, it's the complete opposite. It's just a plug and play. You're inputting stuff into a web page. And so I think, to your point you made earlier in regards to she may be making some statements that's in contradiction to her religion on the services she provides. There's not going to be any statements that she's making. And I think the petitioner and the respondent have stipulated to that. Stipulation meaning they've agreed to that fact, that this is not an explicit statement she's going to be making, but the web page itself is symbolic speech. And so that's important for the audience to know that she would not be putting any explicit statements supporting same-sex, but because, at least from the petitioner's argument, from how I understand it, because the service she's providing, it is a symbolic services. It's in other terms, how the petitioner phrased it, counsel for petitioner, an endorsement of same-sex marriage. So I hear what you're saying, but I just want to clear that for the record, if you will, that she would not, and if you listen to the argument, the petitioner and the respondent seem to stipulate on that fact that there would not be any statements made explicitly stating support, but because she would be providing that service to a same-sex couple, she would in fact be endorsing it, which is why she claims a violation of her free exercise and First Amendment rights. So that's a comment I wanted to make. I think another comment you made, which I also agree about, because I think it's important that we do not get stereotypical in these types of cases. And I think it's easily to be, it's easy to say that someone who's liberal or someone who's gay or identifies with the LGBTQI plus community would automatically oppose and be against the petitioner's argument. But that's not the case, because from my research, there's actually same-sex couples and people who identify with the LGBTQ plus community that are actually on the petitioner's side. So I agree with your point that we shouldn't be stereotypical about this. At the end of the day, and as I stated early on in this episode, is that I think we all need to seriously consider what's going to take place in this case. Whatever side you're on, whether you're Democrat, Republican, Independent, whether you support same-sex or not, these are going to have implications for all of us, business owners or not. And it's really not about the same-sex stuff. It's about, should we allow the government to be compelling our speech, irregardless of your religion, just in general. Let's not even talk about religion right now, just in general. Is that okay? Is that inconsistent, or does that contravene with the Constitution? And for me, I think it does. Right now, I do think it does. And so that's kind of where I want to leave it. And I think it's going to be interesting to see how they rule. I think I have an idea of how they're going to rule in this case. And I expect they're going to give a decision out sometime in the spring or summer of next year, 2023.
So to respond to what you were saying about that is symbolic speech and that she would just be endorsing, I firmly disagree with the characterization of that statement, because it's very dangerous, right? So this is her website, and yes, it is a public accommodation, but CADA, as we said previously, does provide more protection for same-sex couples. If you're compelling someone to post statements of condoning and or endorsing, and just to say, oh, well, that's symbolic speech, like, oh, well, like she's not explicitly characterizing her own views into the website, I think that's very dangerous. And I definitely don't want to get into any rhetoric of characterizing or saying, well, not a big deal because of the fact that she is just plug and play, right? So to her, it's not just plug and play. And I think that if someone has a sincerely held religious beliefs, then I think they have a right to refuse or not be compelled to post statements or condone something that is against their sincerely held religious beliefs. For us to subjectively say, well, it's just plug and play, I don't think that's fair. So something else that I wanted to say as well, I think that's it. I would just say that, again, like I do agree that the implications of this case is something that we all need to think about, especially since we are very privileged to live in a country where we do have a U.S. Constitution, where we do have a First Amendment right. We see that those rights have kind of been challenged in a way. And it's very chilling, like I've said before. This case is extremely chilling for people that have sincerely religious beliefs, regardless of your religion, regardless of your sexual orientation, regardless of your race or color. This is a chilling case for a lot of Americans. So again, glad that we were able to come together and talk about this case.
I am too. And I think there's a lot of other Supreme Court cases that are also just as contentious that hopefully Tamara and I will talk about in the future, but we're excited for what the new year will bring in regards to WAP and the topics that we discuss. So thank you all for tuning in.